Appellate Division, Supreme Court, first call. Here, all persons having business with the Appellate Division who are here, in the attendance, you shall be heard. Please be seated. So good afternoon. We granted your request to hear arguments at noon. So we will then begin with those arguments. Who is present? Who's the gentleman in the back?
Your Honor, good afternoon. David Bloom from Kaufman Board, Easton Ryan. Here to introduce Mr. Eric Baxter from the Beckett Fund, who came up from Washington, D.C. He's been granted pro hoc admission, and I would ask that he be permitted to argue today.
Yes, that application is granted. So we're allowing the total 15 minutes for each side. Do you actually need that, or do you think you need less time?
I might for 15 minutes, let you reserve for rebuttal. That's okay.
Okay, so that's 11 and 1. And? I'm sorry? Okay, so we will proceed then.
Good morning, Your Honors, and may it please the Court, Eric Baxter on behalf of defendants Yeshiva University and President Rabbi R.A. Berman. The Jewish religion and practice is at the heart of Yeshiva University experience. Students spend 5 hours a day, 6 days a week for their entire undergraduate experience studying the Torah with rabbis. Their professional studies are interwoven with Jewish law and tradition. There are formal prayers in synagogues throughout campus. The law of Sabbath, dietary kosher requirements are observed. Sports teams do not play on the Sabbath. And you'll see students with their kippahs on the court and in the field. The university closes early on Fridays and at all major religious holidays. There are mezuzahs on every door. Students come to be immersed.
Are students required to attend religious services?
Religious services are part of the Torah studies experience.
No. My question was, are students required to attend religious services?
If students are required to participate in religious studies, which include religious service, if a student skips out, the university will talk to those students, encourage those students, and encourage them to attend.
I'm sorry.
So you have, at least when I went to college, it might have changed now, I don't know. But when I went to college and I went to law school and even high school, there were required courses, right? So you had to go to math class. You had to go to a language class. You had to go to science, biology. In law school, you had to go to contracts, you had to go to torts. So I think the question for my colleague is, do you have to attend that religious studies class? Is that a mandatory class for all students in the university?
Yes, mandatory for all students to participate in those rabbi-led religious studies classes.
And we're talking about all the schools in the that comprise yeshiva?
All undergraduate students are required. The undergraduate program is designed to be an immersive experience in Jewish law and tradition, and all undergraduate students have to participate in those classes.
The university at the undergraduate level does have students who are not of the Jewish faith, am I right?
The university does admit students who are not of the Jewish faith. It's very rare for that to happen. It's usually students who are interested in converting to Judaism or exploring Judaism, and so they would also be required to participate in those classes.
Irrespective of whether they wish to or not?
That's correct, Your Honor. That is, and students know that. When all students are given an individual interview where they are taught about the nature of the undergraduate program, the immersive experience, the expectations for Sabbath and kosher observance, all of those things are made. Students choose specifically for this experience. The plaintiffs themselves have noted that they wanted to come to Yeshiva University to be a part of this religious environment. There's only one university in the nation that allows this kind of an immersive undergraduate program, and the students come here for that.
Counsel, has there been any instances where Yeshiva University has held themselves out to be a non-denominational institution, for example, in their 1967 charter, or maybe the 1995 fact sheet, or applications for bonds?
Yes, there's no question that Yeshiva University is open about its religious identity. I would point, for example, to the
Sorry, slow down a little bit. There's no
Yes.
question as to what?
No question as to the university's openness about its religious identity, particularly in those situations where.
The question my colleague poses has to do with the non-denominational characterization that the university has used on different filings.
Thank you.
The Plaintiff's Counsel has pointed to a couple of documents where the university has correctly identified itself as a non-denominational educational institution. On documents, for example, the form Char 410 at 630 in the record, where it specifically says, do not check the religious boxes. It will not be recognized unless you can attach certain forms that only apply to hierarchical organizations, like a denominational directory or proof of control by a hierarchical
Counsel, are you saying
organization.
that the university has characterized itself as non-denominational in its charter, in its 2018 application to the Attorney General's Charities Bureau, and in its fact sheet? Are you saying that all of those characterizations were inaccurate?
No, Your Honor. Judaism is composed of many sects and denomination, and the university has, for many years, addressed, for example, if you look at plaintiff's own historical resource that they cite to, the Men and Women of Yeshiva book, there was concern in the 1960s about only attracting students from the flourishing Jewish day school movement, and they wanted to attract Jewish students from all strands of Judaism. And so they have defined themselves as non-denominational and non-sectarian, accurately so, because they accept students of any Jewish tradition and also students of other faith traditions if they are interested in pursuing Judaism or understanding its religious tenets.
But that goes back to my question from before. If the school characterizes itself as non-denominational, you're saying that the students are required to abide by religious practices irrespective of whether they're non-denominational themselves.
So non-denominational does not mean non-religious, and the university is open and clear about its religious identity, and students, government officials, there's no mistaking the university's religious identity.
So in 2012, there was a self-study submitted to the Middle States Association of Colleges and Schools. Why you highlighted its dual program of providing undergraduates with both a secular liberal arts education and a serious in-depth program in Torah studies amounting to a second major. It also noted that students were encouraged to see their Jewish studies as complementary to their study of the humanities within their liberal arts program. So again, you're saying that despite this self-study submission to the Middle States Association of Colleges and Schools, that YU, Yeshiva University, still considered itself not to be non-denominational.
The university accurately it does consider itself to be non-denominational. It also considers itself to be religious, and its self-study is detailed and explicit about the religious activities that happen on campus. Every university, religious institution of higher education in New York offers both secular professional studies degrees along with its religious programming. Under plaintiff's view, none of these schools could qualify as religious simply because they offer professional programming. But that's the purpose of a religious institution of higher education.
But counsel, why did, if what you're saying is correct, then in the 2012 self-study, why wasn't Jewish studies characterized as mandatory as opposed to being complementary to this, the student study of humanities within their liberal arts programs?
That refers to it's complementary to the professional studies. They go hand in hand. They complement one another. It doesn't mean that they're not mandatory. And every student knows that they are required to participate in these classes. And
so, counsel, let's get back to the bond. So now the state dormitory authority's $90 million bond offering in 2011 stated that YU is an independent, co-educational, non-sectarian, not-for-profit institution. Classrooms and dormitories built with the funds would not be used for sectarian religious instruction or as a place of religious worship, except that the free exercise of any religion was not prohibited. So this was a $90 million bond offering that I think was accepted by YU. And in accepting the bond, YU is stating again that it is a non-sectarian. Is that correct?
It has stated it's non-sectarian, again, for the reasons that I stated, that it will accept Jews from any strand of Judaism, as well as other students who are interested in pursuing Judaism. And there's nothing, it has complied entirely with the requirements of the DASNY bond. It has not used the funds for prohibited purposes, and it has also recognized that it is free to continue to exercise its religion, as stated in the document. The court, it would be unconstitutional. The United States Supreme Court has held 3 times in the last 3 years, in the Trinity Lutheran decision, in the Espinoza decision, and in the Carson versus Machinen involving schools, that said you cannot put religious schools to the unconstitutional choice of abandoning their religion.
Okay, so let's get to that. How then, assuming that what you're saying is correct, that it, in terms of the its religious corporation, et cetera, how then would the LGBTQ club in any way require YU to abandon its religious teachings?
Well, Your Honor, I'm not an expert on Judaism, and that is why the City Council, not I, the courts cannot make decisions for Yeshiva University about what's religious. There's no dispute that its decision was a religious decision. And I would add that Yeshiva University does have a club for LGBTQ students. It invites them to participate, to meet together, to have activities, to host events, to support one another, all with the full resources of the university. We're talking about a very small and nuanced religious decision about the name of the club and whether the university can be required to put its imprimatur on a specific club.
So the existing club that you refer to, is that housed at the undergraduate campus, or is it housed at Cardozo and all at, let's see, Cardozo, School of Law, Einstein Medical School, and then the School of Psychology?
It's housed at the undergraduate program. It was created specifically to help meet the needs of the plaintiffs in this case. The university cares about their needs, wants them to feel welcome and invited at the university, and wants them to have a space where they can address their concerns. The plaintiffs acknowledged in the complaint at page 56 that there was a dispute over the name of the club and some other aspects of the club that the university wanted to just be able, like it does for all clubs, student government leaders sign an affirmation that they will uphold the religious environment on campus in approving clubs, and the university wants to maintain that authority, and the plaintiffs have objected to that. It's a very small religious dispute, and that's at the very heart.
So if the club changed its name, this would be acceptable to you? Not to you, sir, sorry, to the university?
The university has formed a club under the name Kol Yisrael.
No, that's not what I asked. If the club in question changed its name, but continued with its purpose, its character, and so on and so forth, would that make the difference to the university?
Your Honor, I'm not sure all of the things that the rabbis would be concerned about, but I know that the name is one of them, and the ability to approve, as with all clubs, the activities and the promotions of the club on campus. It's about—
What is the name of the clubs at the other campuses, the 3 other campuses? Is it different?
I'm only aware of a club on the law school, the Cardozo Law School campus. There have been informal clubs on other campuses.
And what is that name?
I don't know the name of the club, but the university has
I
distinguished—
thought in the record it stated that there was also another club, LGBTQ.
There have been different clubs at different times. The medical school is no longer part of the Yeshiva University, and I think that may have been the specific club that was referred to in the record.
So, counsel, I think that maybe was not clear in my question to you. My question to you was, in your briefs, in your argument, you state that if YU was required to fall under the city human rights law, that it imposed a burden on YU's religious beliefs by requiring to curtail its mission based upon what these clubs, I guess, what they stand for, or what their mission. So my question to you is how? How would this require YU to curtail its mission?
Well, the NYCHRL also prohibits discrimination on the basis of religion. And so all of the religious-based decisions that university makes in its hiring and its sex-segregated campuses, in reserving space in its or excluding from its synagogues non-Jewish
But we're not
worship.
talking about admissions, and we're not talking about hiring.
But
We're
the,
talking about a student club.
but the consequence of finding that the trial of Supreme Court's decision that Yeshiva University is a public accommodation would expose it to all of those consequences of the law. And that's why the plain language of the statute.
So therefore, there would not be any consequence to discriminating against an individual based upon their race or their gender or national origin?
Your Honor, the NYCHRL provides an exemption. And first of all, Yeshiva University wouldn't do those things, but the NYC.
But you're saying that it doesn't matter what you would do or what you would not do because under the statute, if you're not required to act accordingly under the statute, then you could do what you want to do, right?
That's a choice the city council made to exempt clubs, private clubs of up to 400 and even larger if they don't charge money to outsiders, to benevolent organizations.
But you're not a private club.
We're not a private club, but we're exempt under the same language.
But then I guess it brings us back to the first point that we came out here and made, that Yeshiva University itself has taken itself out of any exemption by its own representations, by saying that they are non-denominational, they are for education purposes. So I just don't know, where do you reconcile the representations made by YU itself as opposed to with the city HRL?
Non-denominational does not mean non-religious, but even the plaintiffs and Supreme Court recognize that yeshiva is religious for purposes of the First Amendment, and that under the church autonomy doctrine and the free exercise clause, even if the statute didn't have two exemptions that exempt it, the First Amendment would protect yeshiva universities. There's no dispute that it's religious for purposes of the First Amendment. And the plaintiffs rely simply on the Serio case, which says that it was not addressing church autonomy because that was not a case that required the court to put its, to lend its power to one side or another of a religious dispute, which is what's at issue here. And it's also not binding on the free exercise claims because Serio did not address secular exemptions like those at issue in this statute, which clearly trigger and undermine strict scrutiny under the Tandon, Fulton, and Kennedy cases that have arisen in the last 3 years. Your Honor, I see that my time has expired.
We have one additional question, Counselor.
Yes. With respect to the 1995 Yeshiva University fact sheet that was issued, that fact sheet stated that under the city HRL, Yeshiva could not ban gay student clubs. So how do you reconcile your posture today before this court with what Yeshiva has put out publicly? Once again, the references are all made to documents which were submitted or authorized by Yeshiva.
Your Honor, there's a 30-year-old memo. I don't know what the law firm was considering there. It was actually focused on the religious principles exemption, which plaintiffs at page 41 of their brief admit protects Yeshiva University. They say that Yeshiva is religious for purposes of that exemption, which also protects its right for such decisions as are contemplated.
The fact sheet, counsel, I don't know that it's, I don't know that the law firm is in issue. It's Yeshiva University's position that's an issue. It indicated that the university attorneys, after conducting an exhaustive review of the law, concluded that the university could not use the religious exemption provision to ban gay clubs based on its charter, its actions, and its representations that the university's legal status is a non-denominational institution. How do you reconcile that position from the past and all of these submissions that have been made, including submissions to get a lot of money from the state dormitory authority, $90 million bond? How do you reconcile that with where we are today?
Your Honor, a legal mistake in the past 30 years ago is not binding on the university.
Is the $90 million bond application a mistake?
It would have been, the religious status of the university could not have been considered in issuing that bond under the United States Constitution. It would have been unconstitutional for DASNY to consider the religious status of the organization. There's no evidence that it's ever violated.
Counsel, you talk about an era in the past, in 1995. You're stating that that fact sheet and the submission by that law firm was somehow in an error. But it appears that you followed the recommendations of that law firm concerning not banning gay clubs, and also concerning the fact that you fell within the HRL. So I do not understand.
Well, thank you, Your Honor, for raising that, because in fact, the university, in the memo itself, the university said it would not allow this club at the undergraduate level, and there's no evidence that it has ever changed its religious practices and identity in that respect.
In all of your filings since 1995, and we went over this, from the self-study to the bond, you have referred to the university, not you, but YU has stated that it is a non-sectarian liberal arts school.
Your Honor, that does not mean it's not religious, and the courts.
No, and we're not saying that it's not religious, but I mean, you can't kind of have it both ways, and it seems to me that you are attempting in some ways to have it both ways. And that's what I think that's the issue that we're grappling with. Because it seems like, on the one hand, when you are attempting to secure funds, $90 million, or when you're doing certain filings, then you're non-sectarian. But on the other hand, when there's an issue in terms of clubs, then you're religious. But you can respond to that on your rebuttal.
There's no evidence that anyone.
On your rebuttal.
Oh, thank you, Your Honor.
So you sit down and she goes. Thank you.
I'm sorry, I'm tangled. Good afternoon, Your Honors. May it please the Court. Catherine Rosenfeld for plaintiffs, respondents, the YU Pride Alliance, and a number of individuals. I'd like to start, Your Honors, by answering directly several questions that the Court asked opposing counsel. But before I do that, I'd like to say that plaintiffs, respondents recognize that Yeshiva University's religious beliefs are sincerely held, and my clients are also observant religious Jews who chose to be part of this university. We understand that reasonable, honorable people could have different views about the relationship between the Torah and LGBTQ values. But this case is not a referendum on what the Torah says about LGBTQ relationships.
Counsel, can you just address your position in light of the Supreme Court's ruling in Fulton v. City of Philadelphia in terms of public accommodations?
Certainly, Justice Pitt. In the Fulton decision, the Supreme Court told us that if a statute has an entirely discretionary exemption for sexual orientation discrimination, it is not generally applicable and may raise constitutional questions. And in that case, the city of Philadelphia had an exemption which allowed a single official to exempt from the statute based on sexual orientation. There is no exemption in the New York City human rights law for sexual orientation discrimination. There is no exemption in the New York City human rights law which gives discretion to a single official. The statutory scheme that is in the New York City human rights law that is at issue here has been approved twice by the United States Supreme Court, one in the New York State Club Association case in 1988, where the court looked at this statutory scheme and approved it, and again in Hurley, where it was cited as a proper set of exemptions for purposes of an equal protection analysis. So the Fulton case does not have any application to the facts here, Your Honor, because what we have is the New York City human rights law is a generally applicable neutral law. It does not target religious exercise in any way. It has a narrow exemption for 3 small membership-based entities where business activity and professional opportunities are not implicated, and therefore the purposes of the human rights law are not harmed by carving those out of the public accommodations law. Those are small clubs, benevolent.
Yes, but why you states that it is exempt from the definition of a public accommodation under the city HRL because it is a religious corporation incorporated under the education law.
Thank you, Justice Weber. Justice Weber, the exemption for religious corporations is not an exemption for a religiously affiliated university or college. The exemption is a narrow one for a religious corporation, which is a place of worship or religious observance. That's a legal status under New York law, under the Religious Corporations Law. If the council had intended to exempt religiously affiliated educational institutions, colleges, universities, such as St. John's, such as Fordham, such as Yeshiva, it knew how to do that because at 807.12 of the Human Rights Law, there's an exemption for religious institutions and organizations. And those groups are allowed to give a preference, as Justice Gonzalez noted, I believe, for hiring, employment, housing. So the city council in that exemption said, if you're a religiously affiliated university, they use the term religious institution or organization, so it could be anything of that type, you're permitted to hire co-religionists and to give preference to them to advance your religious principles. But that is not the phrase that was used in the definition for public accommodations. The council used a much narrower term, a religious corporation. And the reason it did that is because it was not exempting a broad swath of religious organizations and institutions from the public accommodations law. New York City has one of the most progressive and protective human rights laws in the country. And the court, of course, is familiar with the statutes of construction, which require it to give the statute the broad remedial reading that it needs to eradicate discrimination and to construe exemptions narrowly. And so when we do that and we look at the term that the council chose, it's a very narrow exemption for private places where there are no business or professional opportunities that would exclude people from the benefits and harm their equal opportunity.
Has that exemption been somehow amended in the human rights law since 1995?
Justice Mendez, are you asking if the exemption for religious corporations has been changed?
Yes.
No, Your Honor. When the law was changed to ban discrimination against women and other minorities in private clubs, this was the language that was put in place there in 1984, and it has remained there since then.
So when Yeshiva's council stated in 1995, in the 1995 fact sheet, that Yeshiva University would not be exempt under the city human rights law, that would still be the case today.
They were interpreting the same statute, Your Honor, yes.
And just to follow up on that, in 2001, Levin versus Yeshiva University, did Yeshiva University concede that they were subject to the city human rights law?
They did, Your Honor, and the Court of Appeals notes that, as you're mentioning, in the Levin decision, they say that Yeshiva University concedes that it's covered by the New York City human rights law. And I think what the issue that has now come before the court is not whether Yeshiva University is a religious corporation under this exemption. It's not. It's clearly not. It's not incorporated as one. It doesn't act like one. It's not a place of worship. It's not a religious corporation, and that's not a close call. What Yeshiva's issue here is that it wants there to be an exemption from the city human rights law for religiously affiliated educational institutions. That's not what the statute says. If Yeshiva wants that, it has to go to the city council, and it has to convince the city council to broaden the exemption from the public accommodations law to allow religiously affiliated universities to discriminate. And it can do that, and there could be an interesting public debate in New York City about whether that's how we want the law to be. But that is not the law today.
So counsel, your adversary says that to the extent that students are observant on campus, participate in religious studies and religious services, the school de facto becomes a religious corporation. What say you?
I say that's not the case, Your Honor. We don't have a statute. This is, as a question of statutory interpretation, The court is not being asked to conduct some subjective inquiry into how religious different components of Yeshiva University are. As one of you pointed out, it has 7 graduate schools, it has 3 colleges, it has 5,000 students of all religious denominations. There may be different levels of religious observance within the university, but that's not what the human rights law exemption asks the court to do. That would very much entangle the court in a very subjective analysis of how religious a certain institution is, a certain hospital, a certain educational facility, in order to determine if it's exempt. But the statute very clearly avoids that, because it says you have to be a religious corporation. And there's 2 ways to analyze that for the court, which is what the Supreme Court correctly did. You start with the certificate of incorporation. Yeshiva doesn't represent itself there to be a religious corporation. It says it's an educational corporation. But okay, there are some cases where somebody incorporated under a different statute, but they still are in fact functioning as a religious corporation. So then you look at whether they're a place of worship or religious observance. All the cases that we have before you involve then a determination. Are you a temple? Are you a Buddhist temple? Are you a church? There is no place for a 5,000-person university that provides career opportunities, professional development, employment opportunities, the purpose of a university, to not be a covered public accommodation under our broad law. But I would like to add that in response to the question that Mr. Baxter was asked about whether students are required to participate in religious, I don't exactly recall the court's exact word, I don't want to misstate it, but the record is clear that undergraduates are not required to participate in religious services, and that's record 523, 524. There are Jewish studies which can be completed in different ways. You could take a study class in Jewish literature, there's lots of classes you could take in Jewish studies, but there's no requirement of religious services. But again, I don't think the court needs to go into measuring the amount of religiosity in the school. It's a large, complex, multifaceted university, and the court looks at what is its corporate organization and form. Is it a place of worship? The court can also then look at the legislative intent to bolster the first 2 answers to those questions and say, the New York City Council provided these exemptions because it wanted to allow membership-based groups to make choices about who could join with them. So if you're a small private club, if you're a church, we're not going to force you to take certain members. That exemption has nothing to do with whether LGBTQ students at a major educational institution in New York City are allowed to be treated equally. And I do think that, Justice Weber, your point that it would allow much broader discrimination by any religiously affiliated educational institution. And I appreciate Mr. Baxter's point that Yeshiva University doesn't intend to discriminate based on race or gender or national origin. But what he's saying is that the law would allow Yeshiva University or any other university to do that. There's no limitation that it even be related to their religious principles.
Right, the response that I should have given or stated is that where in Yeshiva University would most probably not do that, it would set a precedent for other universities in similar stead to possibly do that. But again, I think the argument was that based upon the fact that it is secular and it is preparing individuals, in the study of the Torah, religious studies, et cetera, that the mission or the goals of the LGBTQ club are in opposite to the goals stated by this sectarian university.
Your Honor, my clients want to have a peer support group on campus. Yeshiva has never said that any of the activities that my clients want to engage in together is a problem. They want to have a book club. They want to deliver packages to each other before the holidays because sometimes it's hard for students to go home when they are LGBTQ to unwelcoming environments, perhaps. They want to support each other in an environment where sometimes it can be very difficult to be an LGBT person, and there's a lot of evidence in the record.
Counsel, why wouldn't the club that already exists serve that same purpose?
Your Honor, there is no existing club, and I just thank you for raising that. What Mr. Baxter said, that what Yeshiva University has an LGBT student club, first of all, is not in the record. There's no record citation for that. There is no LGBT student club on campus. There is no club led by students, created for students, around students. The YU Pride Alliance continues to function unofficially off campus without resources, unrecognized. So Mr. Baxter's record citation of Yeshiva University's public relations effort mounted in the last month is not in the record, and I can assure you there is no LGBTQ student club at the university.
Also, a different question, but related. So is the issue here the name of the club, or is the issue here the membership of the club?
Your Honor, it's very difficult to pin.
In other words, if the club was named, I don't know, Monday afternoon club.
I don't know, Your Honor. It's very difficult, as the court has seen, to get a straight answer, frankly, out of Yeshiva University about what it is about my client's club that is a problem. But accepting that there is a religious objection to it, the question before the court is whether the religious objection, a sincere religious objection, means that the club, that students can't get equal resources on campus because they're LGBTQ. And it doesn't. Even if Yeshiva had a sincere religious objection to the idea of an LGBTQ club, because they're a covered public accommodation, because the New York City Human Rights Law is neutral and generally applicable, they have to allow it. And they have allowed it, as Your Honors have noted, for many years in other parts of the university. And what I would say, and just to close, is that in the record, there's a lot of information about how the educational environment for LGBTQ students in universities and campuses can be very difficult. We have the expert report of Dr. Garvey at 1256, 1281. We have several amicus briefs, one from psychologists at docket 77, one from Legal in the record, a climate survey. It's hard to be an LGBT student in a university, and they have higher rates of depression, of anxiety, less academic success. They feel excluded often. And what is also shown in the research that's in the record is that these clubs and these kinds of organizations help students succeed, they help them belong, they help them attend, they are a source of support and strength for these students. And that is what this club is about, Your Honors. And that is the purpose of the New York City Human Rights Law. It's to protect people like LGBTQ students at YU from not getting second-class status at a major New York City educational institution. Thank you.
Thank you.
Your Honor, if I may, on the issue of the club, counsel represented that she knows there's not a club, but her clients have issued a statement opposing the club because they said they want to control the name of the club. They said in their complaint, again at page 56 of the record, that the name was one of the sticking points of the club. There's no question that our clients want their LGBTQ students to have a club. They've done extensive work to promote anti-bullying principles, to...
So, counsel, I had asked you this question before. You didn't say any of this. So the problem is the name of the club, not the membership, not the activities, not the context. The problem is the name of the club?
It is absolutely not the members of the club. The issue is, I'm sorry, it's not the members of the club. The name of the club was one of the sticking points, and the university's ability to approve activities as consistent with the religious environment on campus. It's not these particular plaintiffs. It's the plaintiffs and students down, future students.
So if
What was the purpose of the club? Is that what you object to, the purpose?
No, the university has stated that it wants the students to be able to meet, to have activities, but there's a religious environment there. They said there are nuances that the university has to balance between loving and accepting all students and upholding the teachings of the Torah. And that nuanced message is impacted by the name of the organization, the affiliation with that name to the general public, and that is one of the things that the university is concerned about, along with If Yeshiva University is a public accommodation under the NYCHRL, then it couldn't have any say in what
But
any
counsel,
club
if
does on
the
campus.
university is non-denominational, as it has indicated, you would agree that there are many strands of Judaism, and different strands of Judaism interpret the Torah differently as to lesbian and gay students or lesbian and gay people.
Absolutely,
where do
absolutely,
you-
Your Honor, and the university respects the right of those students. Disagreement is not disrespect, it is not coercion, it
You're
is
saying
not.
it's conditional.
No,
It's conditional respect.
No, the university is just asking that its own choices about what it puts its imprimatur on campus, that it has a choice, its identity has the right to preserve its own identity. It respects its students' choices and what they do. It's never punished students for their choices. It wants to be able to teach what its beliefs about the Torah. And the United States Supreme Court has
So
repeatedly.
I'm sorry, counsel, so you do not, you do not approve of the name? So you want the name to be something else, and you also want input in terms of what the club, the mission of the club perhaps, or the programs the club, or things that the club talks about, that's what you want to have control or input on that as well?
That's right. As we've stated in our opening brief, all clubs' activities have to be approved by the university, and that's true across the board. And the university is just asking to be able to treat this club like every other club.
And every other club, you have had input and approved or disproved their name, and you also have significant input in what they talk about, their goals, their missions, programs, et cetera.
That's correct. And if you look at the record 381 and 398, all of the student government leaders sign an affirmation and affirm that they will uphold the religious values of the institution. There's a process where that can be approved by student life and ultimately by the rabbis and the president of the
And
university.
so this club did not do that. They did not sign an affirmation or attempt to sign an affirmation that they would uphold
I'm saying,
religious values.
excuse me, the student government leaders who have to approve clubs, they sign an affirmation.
And so was there anything stating that this club would not be able to adhere to that, upholding the religious values of the school?
That is the dispute. That's the reason why we are here, is because the student club has indicated that it won't submit its name approval to the university. It wants its own name, and it doesn't want. It stated that it wants to make its own decisions about its activities, and all clubs on campus are subject to review by the university. Now, I would just note, Your Honor, that the plaintiff's counsel has agreed that yeshiva is protected under 8-10712. She said that they can make decisions about admissions and hiring and housing but that same provision also protects the university's ability to make such decisions as are contemplated to promote its religious principles. She ignored that.
But that are not discriminatory, right?
No, it exempts. She's admitted that it's exempted from those requirements under the NYCHRL. And Fulton, she says that this law is neutral and generally applicable, but there are categorical exemptions for clubs of up to 400 and larger, as long as they don't charge money. For benevolent orders like Elks Club, where there are lots of business transactions, social interactions, the third department has said that these organizations are categorically exempt, absolutely and without limitation. That is a choice of the city council, and the legislative history shows that the city council chose that specifically because, out of respect for the religious constitutional concerns. The United States.
So, counsel, how do you parse the testimony of Rabbi Kalinsky, who's the dean of undergraduate Torah studies at Yeshiva, where he said that the reality is that the control works through influence. You're talking about control. You're talking about controlling content as well as identification as well as name. Aren't you contradicting what the dean himself said?
No, Your Honor. Under the Jewish, Orthodox Jewish tradition, rabbis make decisions and they lead by influence. They don't force students to do things they don't want to do.
You're talking about control. You're saying the name is no good and you want control. Not you.
I understand, Your Honor. The university is entitled under the First Amendment to control its own identity on its own campus. And that is what the university is asking to do here, that it not be forced to put its imprimatur on something that it sees as inconsistent.
What happened with Einstein and what happened with Cardozo and what happened with the School of Psychology?
The university has always distinguished between its undergraduate and graduate programs. Its graduate students are not required to participate in religious studies. They do not go there for that purpose. They're not required to engage with rabbis in prayer and other religious observance. They're religious across all of their campuses, but the immersive.
There's another school, right, a rabbinical school that Yeshiva University broke away from in the 1960s, and that particular school is more so religious for the purpose of producing rabbis. Am I understanding that
They are
correctly?
separately incorporated, but these two universities are fully integrated. The REACH does not have its own campus or buildings. It meets in the same classrooms with the same rabbis as the undergraduate students. It's fully integrated into an undergraduate campus. For whatever reasons, they're separately incorporated, but that speaks nothing as to their religious identity. Plaintiffs have again admitted that yeshiva is fully religious for purposes of the First Amendment. The Supreme Court has already indicated that this case raises shocking questions of the First Amendment, and the Court of Appeals in the Viviani decision held that the court must construe a statute in a way that avoids these constitutional problems. And the way to do that is by applying the plain meaning of the statute. The statute states simply that a religious corporation incorporated under the education law. Plaintiffs are pulling from the definition of a church under a separate law. Even under that separate law, the religious corporation law, it says that a corporation is religious if it has a religious purpose.
So,
But
Council,
also if it's registered with the state as such, right?
No, there is no requirement under, you have to, in fact, under the law, Yeshiva University is required to incorporate as an education law corporation, as is every institution of higher education. And so religious corporation, there's undisputed that it's a corporation under the education law. It's also undisputed that it's religious unless you adopt plaintiff's made-up definition that religious means you have to be a church or a place of worship. There's
No,
nothing in the
I think that was the
statute.
definition. I don't believe it was made up. I think that's the definition
That's
under
the
the
definition of a
statute.
church. That's the definition of a church under the religious corporation statute. It's not a, there's no
That's a
definition.
definition of a religious corporation. But again, I think, Justice Gonzalez, you have another question?
I'll pass.
Okay, thank you both. Thank you so
you, Your
much.
Honor.
Have a good day.